All right, welcome back to another episode. This is now episode 3 of Beyond the Bench, and it's a podcast all about Mountain State's approach to advocacy and success. And today we got the awesome Todd Scott, and he is a part of the Counsel on U.S. Supreme Court litigation defending free speech, as well as a strong advocate of the liberty movement, on all the way from Missouri. So welcome, Todd.
Well, thank you. It's good to be here. Well, thanks for those kind words. I should have written that myself, right?
No, you're good. We like to be prepared here at Mountain States, especially at Beyond the Bench. So, Todd, I guess just to start us off, and I love asking everybody this question, is who are you?
Yeah, who am I, and how did I get here from Missouri?
Yeah,
right?
Feel free to walk us through your career path, kind of just how you ended up where you are.
Yeah, happy to. I had a number of years to work kind of in public policy and in the legal movement, and have enjoyed it greatly. My history includes time I spent in the Missouri State Senate on the staff side. I was chief of staff to the president of the Senate and then general counsel for the Republicans. And following that, I worked for a Missouri governor for a while in a kind of a legislative policy role, and then worked for a time in private practice as well. Worked as general counsel to the Missouri Department of Labor for a time, and that was an interesting foray into kind of the work of a general counsel, which was, lots of 800-member department. So any day was a little different. You never knew what was coming in. But then most recently, I served as senior counsel to the Missouri Attorney General's office. And that was a great experience and really enjoyed it, and a lot of fun things we got to work on there, including some cases, as you referenced earlier, that made some national headlines.
Yeah, that's awesome, and I'm very excited to kind of dig deeper later on, I guess, in the episode. But now I see that you're doing basically everything nationwide on a giant level. So, and you said you had time kind of in some private practice. I guess I'm just curious as to what the difference is between doing private and public.
Yeah, it varies, of course, and being an attorney, there is a wide variety of things you can do, which is one of the things that attracted me to the field initially. With the private practice, a lot of good can be accomplished, but a lot of times it's a profit motive of how you can make the firm profitable and so forth. With the public policy side, it is really fun and something I really enjoy because I feel like you're working on issues that are important to myself personally, to my family, to the things I believe in, and I believe also to the nation, to make it a better place. And really, to have a constitutional republic takes a lot of work, and work like the Mountain States Legal Foundation does. Every day, somebody's got to be out there kind of watching the borders to make sure that we're protected against any number of threats.
A lot of what I hear is, and especially when people kind of get driven back to that public policy, is, I guess, the effect that it has, the big just kind of impact that you can make. And just kind of, I guess, rolling back the timeline a little bit, what drove you to law in the first place?
I came about it a bit backwards. My dad had told me at one point he thought I should go to law school, and I thought that was such a silly idea back at that time. And so I started working in policy in the state Senate, and I ended up going back to school and getting a graduate degree in political science and all these things. And then it suddenly dawned on me that maybe my dad had been right all those years and I really should become a lawyer. To me, a lawyer was someone who was in the courtroom, and that wasn't something that had appealed to me at the time. But what I came to realize is that there's any number of things you can do with a law degree. So I jumped back into law school a little bit later than most of my classmates, and I think I graduated when I was around 30, which seemed pretty old at the time, not so old now.
Yeah, I was about to say that's pretty normal.
Yeah, right.
Right now.
Yeah, there you go.
And so you said your dad encouraged you first. Did he see something in you, before you even became a lawyer? You said it was kind of silly, so I'm interested.
Yeah, it's we didn't really have lawyers in our family.
Oh, so you were the first?
I believe I'm the first. And my dad came from we had a family furniture hardware store that was in a little town in Missouri. My great-grandfather started it, and so generationally we had worked there. My dad was also in the legislature, which was a part-time position. So we always had a public policy flair to our family. And for whatever reason, he thought that law would be something I should pursue. And eventually I came around to his way of thinking.
Got good at arguing.
Yeah, I should ask him. I didn't think of myself as an arguer, but maybe I was.
Yeah, that's awesome. Was there anything that I guess you learned? Well, did you work at the generational hardware store?
I did.
Was there anything that kind of helped you going forward as a lawyer, like working there?
I think the neat thing about working around your family and my great-grandfather, my grandfather, my dad, assorted relatives, my siblings, you get an idea of what's important. It was a little town, and our lives centered around family, our little church, a lot of just good people in these rural areas in the middle of what some people would think of as flyover country. And I think it gives you a perspective on what's some things that are important. And a lot of times those things are overlooked, but as conservatives, I think we value and we conserve those things that are traditional and important. And that's one thing that motivates me to this day.
Yeah, I definitely understand that. I'm from Springfield, Illinois, however, so another small town, but flyover country to most.
Right.
So I definitely get that aspect of, tradition, sticking close to your roots and understanding and being there for your roots. It's very, very important. And that's why Mountain States is advocating for it. And I believe a lot of us here agree with that statement as well. So I guess kind of fast forwarding a little bit is what drew you to First Amendment and free speech issues, especially in the context of social media regulation.
Funny how that worked. It was a bit of happenstance. My role at the Missouri Attorney General's office was I was senior counsel, which I think really just meant jack of all trades, master of none. On any given day, there was a new project. And as part of the administrative team, we worked closely with the Attorney General. And so whatever his or her priorities were, that was the priority of the team. And so you never quite knew what a day or a week would bring. And so I got to work on a lot of projects. I didn't start out as a First Amendment attorney in particular. I was there to do just what needed to be done. And then when the Missouri versus Biden, which was later Missouri v. Murthy v. Missouri at the Supreme Court, when that case came along, I was pulled into it, and it became a very interesting part of my time there at the Missouri Attorney General's office.
That's awesome. Yeah, and especially when you get into the weeds of social media, I think things are starting to get more gray, as the day goes on. So let's talk about it, and especially with the I guess the essence of free speech in mind. So during your time at the Missouri Attorney General's office, what were some of the early free speech or internet-related cases you've encountered?
So the big one was what became the Murthy case. That took, in fact, it's still a live case, having been remanded from the Supreme Court. But that was a case that absorbed a lot of our time and energies. It wasn't the only case or project that the Attorney General worked on. I just recently, I've left the Attorney General's office after many years as a state employee. I've retired from state service and now in the private sector with working with American Jurist Link and doing some of the same kind of things. But one of the projects we worked on when I was there was an age verification rule, because when you get into social media, so many of these sites, these websites, don't require young people to verify their age. And these are, a lot of times, you can have pornographic websites, and they're very harmful to kids. And so a number of states have taken to try to enforce some age verification, which we worked on that as well. We also had started to look into kind of the algorithms, like what makes up the secret sauce of some of the algorithms that a lot of people, we see what may show up on our social media feed, but why is it that way? And sometimes why does that disadvantage conservatives, for example? And so those were other sidelights or other projects that the Attorney General's office worked on when I was there.
If you don't mind elaborating on what are some things that you might have experienced that kind of taught you about like the moral and ethics of specifically algorithms, kind of elaborating on that aspect. I'm curious. Is there any moral or ethics that you believe should be integrated more into algorithms or maybe even taken away?
I don't know that I'm qualified to say too much on that point, other than it's such a new area where I think any number of legal groups and policy groups and just those of us that are Americans that are interested in the world around us are going to have to really think more about, because I think when we talk a little bit more here later about the Murthy case and how algorithms played a role in that, and then what what would have happened had that case been 2 or 3 years down the road as those kind of systems matured. I think we're on the cusp of what you might call a brave new world, and I'm not sure people are prepared for what could be coming.
Yeah, I don't think a lot of people are prepared for the world to change. The world always knows what it wants, but not what it needs. I think that's always a crazy paradox as well to think about. But how do you see the role of a state-level attorney or counsel in shaping national litigation on speech and tech policy?
I think it's an interesting role, and speaking broadly for attorneys general, just an observation about those offices, they've become more in the forefront, I would say, in the last 20 years or so, and that, along with other groups such as Mountain States, where you have these public policy groups that are stepping into the gap, because when someone's rights are violated or their First Amendment rights infringed, they may not have, an individual may not have the means to take that case to court. They may not have the financial resources or know how to begin to do that. And a large law firm may not be interested or may require too much in the way of financing to take that case. And so you have these groups like attorneys general, state attorneys general, that move into that role because their role is to represent the people of their state. And they can do that not having to worry about some of the constraints that might be there for a private law firm. And so I see a lot of good that has been done with these groups, with not only with some groups that do this sort of thing, but with state attorneys general that have moved in and stepped into the gap. When I first started at the Missouri Attorney General's office, it was General Eric Schmidt was the state attorney general, and he's now in the U.S. Senate. But he's just recently written a book that talks a lot about this, about how they stand in the gap as there was sort of a leftist wave over the last several years, and some of the ways they were successful in really standing in that gap.
And you talked about some of the constraints that kind of hold you back, and especially being in the world of law and litigation in general, you kind of have to be a visionary and think, 10 years, 30 years? I mean, if you're talking about in the eyes of the Constitution, those guys were thinking hundreds of years into the future, trying to make sure we have the proper rights, I guess, protected. So what are some of those constraints in the modern, I guess, context that kind of hold you back from changing what is a visionary outlook for the future?
It is always hard to look into the future and see what's the next big thing. And sometimes by the time we realize it, it's already gotten difficult because you have constituencies that have developed about one thing or another, and it's hard to change course, even though maybe, as you mentioned earlier, people know what they want, but not necessarily things that are good for society.
Yeah.
So I think you have to really pay attention and to try to just figure out what trends are out there. And I'm not saying I have any special market or corner on that market. I'm glad there's a lot of other folks that are trying to guess that. But there's just a lot of things you would have looked back a few years ago and you wouldn't have thought that would have ever become something of national importance. And there are currents and waves that sweep through the country, and it's important to keep up to speed.
Yeah, I like how you brought up the point of national importance, and there's definitely a lot of debate about when coercion, persuasion, or even quote-unquote encouragement by the government crosses the line into unconstitutional pressure on private platforms, right? Whether that's Instagram, Facebook, YouTube, whatever. How do you conceptualize that line?
Yeah, that is that's the stuff that Supreme Court cases are made of.
Oh, yeah.
As it turns out. And so the Murthy case, which I think we'll get into in a minute, really delved deeply into that. And some of the case law developing up to that point, like the Fifth Circuit that had had the case before it was appealed to the U.S. Supreme Court, went really down that rabbit hole of where is the line. And so when we're talking in the context of social media in this case, what can the government do and what can the government not do? And so I don't know that anyone really disputes that the government can have a voice. They can have a website. They can speak. The president has a bully pulpit. He or she can say whatever, an official can say whatever they think is proper. The question is, can they inhibit someone else's speech? And so I'm a bit of a purist. When I look at what the text of the First Amendment says, it uses this word called abridge. And courts don't normally talk about that. There's different tests, like coercion, significant encouragement, and these kind of things. But I like to get back to the word abridge. The government will not abridge the freedom of speech. And so I think that's a really high bar. I think anytime the government is acting, using its powers in a way that would keep me from expressing an opinion or bridging my freedom of speech, I really feel like that's the safest line to draw. Anything short of that, it seems to allow too much leeway to the government, in my opinion.
Yeah, a little bit of a snowball effect.
Indeed.
Yeah, you got to have a solid line and stick to it. So in your view, what are the most unappreciated First Amendment risks that arise from government platform interactions?
You know, as vast as government, especially the federal government, is, the government really can't be everywhere at once, which is good in my opinion. But what they can do is they can cause people to self-censor. And I think that's a really pernicious effect of some of the things we saw coming out of the Biden administration with their focus on trying to marshal the social media companies to inhibit and to censor free speech. While there was a number of social media posts and other elements of speech that were inhibited, were taken down, people were deplatformed, that all happened. But I think what was more pernicious was all of those citizens, and in some cases thought leaders and so forth, that self-censored because they were afraid it would happen. And it's impossible to measure how large that was, but anytime a free society starts to self-censor because they're concerned about the government penalties of one form or another, then I think you have a really dangerous scenario where people are giving up their own freedoms out of coercion, but it's really hard to measure. And so I do think that's one thing that hopefully we're rolling back the tide on that. There's been some really positive developments in this area, and I'm hoping they'll continue because we need to exercise those rights. You know, rights are kind of like muscles. You've got to exercise them or you lose the ability. So your First Amendment rights, you know, be vocal, be free with your opinion. If it's the freedom of religion, you know, if you're inclined towards that, to exercise your freedom of religion, to attend a church. If your Second Amendment rights are another thing. I know that Mountain States is very involved in the Second Amendment. You know, there's just exercising those rights is, I think, one way to keep them safe and keep them robust.
I love that. I love every part of that. And you were kind of hinting at how we're going to be talking about Murthy versus Missouri, and let's kind of get into it. I'm excited. This is what we're here for. I think this is what I've definitely been looking forward to for a while. And so can you give us a quick overview of what Murthy versus Missouri was about and what drew you specifically towards that case and what your role was in it?
Yeah, no, I was really privileged to be able to be a part of it. And so the Missouri v. Biden case was the case at the district court level. That's the case we filed. And so in early 2021, 2022, actually even going earlier than that, you could see evidence that the federal government was involved in some form or fashion with the social media companies, involved in the sense of pushing, pressuring, dictating to them what posts were forbidden and which ones were favored. And we knew that because there were a number of instances in just the media where you would have the president's spokesperson, Jen Psaki, for example, would talk about, well, we're in touch with the social media companies. You know, they know what we're asking for. We are flagging posts and this sort of things. They were very overt talking about this. And so our team at the Attorney General's office, the Missouri Attorney General's office, took note of all of these public statements. It was very clear that something was going on. You know, this was during the heart of COVID, and you had a number of people that were, their social media accounts were being either completely delisted or taken away, or they were being downgraded or demonetized, where people who made money off of social media would find that their viewership, their listenership was demoted in some way. And so it was clear something was going on, but at that point, nobody could say exactly what. And so that was sort of the background. During the time, it was Eric Schmidt was our Attorney General, and he and the team decided that it was time to to try to look under the hood and see if we could figure out what was going on behind the scenes.
And correct me if I'm wrong, this was also rooted in something that had popped up in, I believe, 2019, 2020 with the Biden emails and them censoring or bringing up something, I guess, later now towards the 2024 elections.
One of the main strains was election interference or Russian interference in the elections, or related to that would have been disagreeing with the official line about election fraud and so forth. In addition to that, there was the COVID was huge, and it's just a few years ago, but I know it seems crazy that we were all in the middle of this sort of COVID crisis where freedoms were being steadily degraded and diminished. In addition to that, there was, related, I suppose, to COVID, were masking and vaccines and all these things. They're developed sort of official government positions on these issues. And if you strayed from that position, if you didn't think masking was effective, if you didn't think drop boxes for ballots was a good idea, if you didn't think that this or that was true and it somehow differed from what the Biden administration thought, you might find that your social media feed suddenly got a lot smaller, or your friends and neighbors might wonder why you're not posting anymore, and you are. It's just they weren't able to see it because behind the scenes there was something going on where those feeds were demoted or taken away entirely.
Yeah, it gives the concept of what I guess now the shadow banning. It's becoming a huge thing within
Absolutely.
Streaming as well as modern day social media. And I just now going back, I guess, towards the weeds of Murthy. One of the central issues that I read about in Murthy was this concept of standing, right? And so, can you define what that is for the audience and why it was so crucial in this particular case?
Yeah, there was a lot of interesting things that came out of Murthy, of course, is the case when it was at the Supreme Court. But one of the things that is a little bit, kind of makes our eyes glaze over when we talk about standing and some of these more arcane legal issues. But as it turns out, those are very important in litigating a case, because to have standing is really your ability to bring the case. There may be something in the world that I don't like, but if I don't have a direct and personal injury, a court usually won't let me bring that case. It has to be someone with a particular injury that has what we call standing to bring it. And so that is always a really large hurdle when bringing a lawsuit. And as it turns out in the case, and I'll call it Murthy going forward because I keep switching back and forth.
No, you're good.
Not to confuse folks, but in the Murthy case, that turned out to be what the Supreme Court really focused on when it reached that level. And I'm happy to go into kind of what they found in standing. Or
Sure, let's do it. Why not?
Yeah, I mean,
educate the people a little bit.
Yeah, I'm probably this is the part where people want to hit snooze, perhaps, but
No.
it is important because the Supreme Court, and we certainly didn't agree with this. It was a 6-3 decision, but the majority in Murthy found that the state of Missouri and Louisiana and several private plaintiffs, our coalition, did not have standing to bring the case. And so on a 6-3 decision, you might say that we lost the case, but it's important to note that the court didn't reach the merits. They didn't talk about what did or didn't happen as much, or they didn't definitively weigh in on what they thought happened or didn't happen. They said that they didn't believe that the parties had standing to bring the case. And so they kicked the case back to the federal district court for further proceedings. Now, I think wrapped up, though, in this concept of standing, and this is where certainly we disagreed with the majority, strongly favored what the minority wrote. There was a 3-judge dissent, which I think is very strong. The majority seemed to draw out a very tight pattern where you would have to show that one particular federal official threatened one particular private party about a particular subject matter with a particularized threat. It was almost so tightly woven that it would be very, very difficult to show that. Not impossible. There was another case that came down that same year, it was a gun rights case in which they did find that there was standing and harm. But there was a letter, I think, in that case where some government officials had been very, very overt and put it in writing. I think the minority, though, the dissent, got it right. They talked about was so clear from the facts we brought out in the Murthy case that a great harm had been done. There was a massive amount of censorship. In fact, I'll read, this is the Fifth Circuit Court of Appeals when they looked at the facts of our case prior to it being appealed to the U.S. Supreme Court. They said this: "So we do not take our decision today lightly, but the Supreme Court has rarely been faced with a coordinated campaign of this magnitude, orchestrated by federal officials that jeopardized a fundamental aspect of American life. Therefore, the district court was correct in its assessment that unrelenting pressure from certain government officials likely had the intended result of suppressing millions of protected free speech posting by American citizens." So that was the appellate court that found that. The Supreme Court declined to weigh in on the merits. But, I think it was so clear that a huge amount of harm had occurred that to not move ahead and to impose a penalty on the federal government was really unfortunate, because I think it kind of paints a roadmap as to what could come next.
Yeah, I think, especially in summary, like I remember reading a lot about how it's this idea of injury, right? And not only that, but you're trying to prove not only. I remember there was a part where you have to prove argument against not only just Meta, but also the government itself, which is like, again, I mean, we talked about it before we started, but the DOJ knows just enough to get by, and that's going to be an extremely hard assumption to link factually between both Meta, then you're going to the algorithm, then you're going to the emails, then you're going to the government. So, oh my gosh, what was it like, I guess, mentally trying to work, like, if you don't mind me asking, like, what was that mental process like, or what was the strategy that you were kind of walking through or running through?
Yeah, we got into the case, and we began to amass as many public sources as we could to try to paint the picture of what was going on. And then we brought those facts that we had gathered to the federal judge, the district court, and he ruled in our favor and let us have limited discovery. Now, the Supreme Court described that as broad discovery. We think we've just got the tip of the iceberg, but we got about 20,000 pages of documents, such as emails from the White House and other federal agencies. And so as we started going through those, the picture became more clear to us that there indeed had been a huge censorship enterprise that had been developed, had been stood up from the White House. It had been pushed out into various agencies. Into Homeland Security was really one of the chief offenders. There is a little-known office buried in Homeland Security called CISA, which is the, if I can remember the name correctly, the Cybersecurity Infrastructure Security Agency. And their job initially was to keep the country safe from cyber attacks, kind of external threats post 9/11. Unfortunately, that agency became weaponized and turned inward on the American people. And so it somehow viewed its position as being to monitor and to censor the social media feeds of the American people. In fact, one of the key members of CISA, Jen Easterly, is quoted as saying that she thought it was a dangerous thing for Americans to get to pick their own facts, and that she felt that cognitive infrastructure, meaning what goes on inside my head, cognitive infrastructure, was within the purview of CISA. Now, if you have an organization who thinks that the thought patterns and the ability of Americans to pick their own facts is something that the federal government needs to have a role in, we strongly disagreed with that.
Yeah,
and,
very unconstitutional.
Very unconstitutional. I think the First Amendment definitely militates against that. So as we got deeper and deeper into it, the more clear it was to us. Just a number of violations of the First Amendment were ongoing. And so we brought those facts to the federal court and received an injunction against the White House and others that ultimately that's what went up for the Supreme Court as at the end of the case.
Yeah, I think, gosh, that's got to be annoying. 20,000 documents and then saying tip of the iceberg. I mean, oh my gosh. And then a very well-made argument as well, very well-constricted. And even if you were to talk about another huge issue was whether the government's behavior could transform a private company's moderation into a state action. What was your reading on that debate?
Yeah, so that was really the heart of it.
A number of cases have been brought against social media companies. In fact, I think Donald Trump, between the time he was president and the 4 years he was out of office, brought a lawsuit against social media companies for kicking him off of Twitter, I believe. And the problem with that is those cases, generally when you sign up on Instagram or Facebook or X, there is a venue selection clause, which means that you will be litigating in the Northern District of California, San Francisco. And so, right off the bat, you're probably going to have an uphill climb. And I think that a number of people found that out. Our strategy was different. We did not sue the social media companies. First of all, private parties can't violate the First Amendment because it's an injunction against the government, correct? And so our suit was against the federal government only. We did not join the social media companies as co-defendants, although we felt they were involved as in the sense that the government pushed them to do its dirty work. And so by doing so, essentially made the social media companies somewhat of an arm of the government. Elon Musk was quoted as saying when he bought Twitter, he goes in there and he said in his words that Twitter, it was the sock puppet of the government. There was so much government intervention and so many former government officials that were involved in Twitter that it had essentially become a sock puppet. It looked like Twitter on the outside, but very much intertwined with government or former government interference.
Yeah, a lot of terms and conditions you got to start reading.
That's right, in the small print. And so that's
very fine printed. Wow, I actually didn't know that you're already arguing in you said the Fifth.
So it
circuit?
would be the Ninth Circuit that you'd be in the District Court of Northern California.
Yeah.
Generally where those cases have to be litigated.
Yeah, very democratic. So yeah, you're right. Very an untraditional, I guess, point of view on those cases. So that's very interesting.
Yeah.
So the Supreme Court remanded on other grounds. Let's define that first before I ask the real question, if you don't mind defining that.
Yeah, so I think what the Supreme Court did with what they found was, we talked about standing specifically, and it's an element of standing, was traceability. And so traceability is connecting the dots in such a tight form that you would have to show, as I mentioned before, kind of a connection between which government official, which violation, which person, which narrative did they inhibit or censor. The Supreme Court said, well, we don't see something that closely aligned, so we're going to essentially kick this back to the district court for further proceedings. Now, the district court has the ability to allow more discovery, to say, well, then, let's, instead of 20,000 pages, what if we did 50,000 or 1 million pages, and we went through and would we find more facts? I mean, that would be one course that would be open to a district court. A court can dismiss any number of things, but the U.S. Supreme Court left the merits of the case unresolved. They really focused just on that procedural portion.
And so what do you think, or what do you expect will happen on remand, or what are the next phases of litigation that you see as crucial?
I think one of the best things that came out of Murthy, while it was not a clear win, although I would encourage anyone that wants to read about the case to go back and look at the Fifth Circuit's their opinion, because it is on the merits. And the quote I read you earlier, where they came down very forcefully on the side of the plaintiffs, saying the government had indeed engaged in censorship. But I think that if you look at what comes next, one of the things that came out of that was so great is perhaps before the Murthy case or before some congressional committees got involved and really started digging in and subpoenaing witnesses to come, and then Elon Musk bought Twitter. What a great thing that turned out to be, because when he got in there and kind of looked under the hood, he could see a lot of the abuses that were going on within the social media companies. All of that narrative came to light, and I think if you were to poll the American people in 2021, censorship might not have been on their radar. They might not have realized to the degree they do now what their government was involved in. I do think in 2025 that the narrative has changed a lot. And so by educating people and really bringing out this into the public awareness that, no, your government was censoring you. Your government was involved in a way that they should not have been. I do think we won on those grounds.
So to answer your question, though, the case itself goes back to the district court. Also, as we all know, last fall when Donald Trump was reelected as president, he issued an executive order. This is Restoring Freedom of Speech and Ending Federal Censorship is the name of it. This came out on January 20th.
This is live. This is in person, too.
2025.
He brought this as pure evidence.
Yes,
yeah,
I did.
in print.
It's all marked up and color-coded. But if you read this, here's one of my favorite lines since I have it in front of me. He says, over the last 4 years, the previous administration trampled free speech rights by censoring American speech on online platforms, often by exerting substantial coercive pressures on third parties, such as social media companies, to moderate, deplatform, or otherwise suppress speech that the federal government did not approve. And so another instance of winning the war after having lost a battle is when the government itself, in the form of the president, comes out and admits that, yes, the federal government was deeply involved in coercing social media companies to censor free speech. We feel like that's a pretty big win as well.
Now, I'm curious, do you think that also kind of twists or maybe even adds a little knot, though, in changing litigation or law for long-term effects?
I think that is the concern, that executive orders are great, but President Trump repealed a bunch of President Biden's executive orders, and I'm sure if if the White House changes hands down the road, there'll be a backlash. And so how do you preserve those First Amendment rights in a way that isn't subject to the next election? And that is the difficult area the difficult thing to really cement. And that's why groups like Mountain States that are out there litigating and trying to get some judicial wins to really make these wins and these advances more permanent are so important. To your point, I do think there's a lot more work that needs to be done. We can't rely on an executive order, as good as it may be. We need to continue to try to push the envelope and to put cases before the court where they can, maybe a different fact pattern. Maybe we get a better ruling out of a court going forward. But a lot of work needs to be done still.
It truly is a chess game.
Yes,
It
indeed.
is. Sometimes you got to go back, retreat. Sometimes you got to push forward. But, oh, my gosh, it's complicated.
It is.
Learned that very quickly.
Yeah.
I've only been in this role for 3 months working in law. And, I mean, you have many years of experience on me. So I couldn't imagine all the different strategies.
I was a player on a team and the team that I was able to work with, they were the true experts. And we had in fact, the lead attorney through the life of this case, the vast majority of it was John Sauer is his name. He was Missouri's Solicitor General. He's now the United States Solicitor General. And so he is a brilliant attorney, and a lot of credit goes to John Sauer for the way he marshaled the facts we found and really created this compelling narrative that of the censorship that the government was doing.
And I'd like to kind of just look forward and talk about what this can kind of mean for the future. So in cases like Murthy, how do you think about the risk of bad precedent? And an example, even a favorable ruling might open doors to undesirable future government constraints on platforms.
Yeah, one of the more disheartening parts of Murthy was and I think the dissent says this well, and I'm paraphrasing, but you could read the majority opinion as painting a roadmap for censorship. In my view, the requirements were so artificially high as to what they were looking for that it wouldn't take that much effort for a future administration that wants to censor certain types of speech to do it in such a way that they don't leave fingerprints. Through the course of this case, as we're looking through just thousands of emails and documents, we started seeing this disclaimer that the employees of CISA started adding to their emails. And I can't quote it verbatim. It was lengthy, but here's essentially what it said was, nothing in this email is designed to inhibit the First Amendment. And if you think, we're violating your First Amendment rights, you're wrong. It's something just blatantly
very in your
top.
face.
Very in your face. But it was so obvious why they were putting that there. It was because they were indeed censoring. And so if we add a disclaimer that says we're not, then it might help our case. Well, sadly, the U.S. Supreme Court took note of that disclaimer, which I've really felt like the disclaimer itself was so patently contrived to try to cover up bad behavior but it was unfortunate, because you start to see that if future government officials are cagey enough to add disclaimers or to make sure that they don't leave a trail of breadcrumbs, so to speak, that maybe they can get away with this. You mentioned the role of algorithms, and one of the big concerns after the Murthy case was, I feel like we caught the government kind of with its hands in the cookie jar, but they were in the middle of sort of bridging from an analog world to an algorithm, a digital world, where one of the things was CISA, this group I've referred to before, had this switchboarding, they called it. So they literally had college interns, some of whom worked for CISA, but also were interns at Stanford. And they developed this whole switchboarding system where they would review emails, and they would flag certain emails that they didn't like, and they would pass those along to the big tech companies. The big tech companies, in many cases, would then take those down. And while it did rely, I think, some on algorithms and so forth, there was still a bit of hands-on, human beings in there trying to sort out and ferret out offending social media posts. Going forward, the next time the government tries this, and sadly I think this will happen down the road, that is the nature of things, is if it's all done by an algorithm, if it's done by a computer moving at light speed that doesn't necessarily involve human interaction other than an algorithm that's designed to suss out and to then pass along tweets or whatever we call it, social media posts or any kind of free speech, I think that's where it gets really dangerous. Easier to hide.
I agree, and I think I have an interesting kind of, I guess, next point to follow on to is, now that you bring that up, is there's always going to be a guy on deck, right? That's going to be, let's step in, let's do something. So what, I guess, strategy or tactical advice would you give to other states or litigants thinking of taking on cases that challenge government platform pressure?
Yeah. To be strategic, and to watch for those fact patterns that maybe you can draw that tight link. There have been a couple of successes. I mentioned there was the case with the NRA out of New York, Vulo, I think it's called, that hit the Supreme Court, and we got a ruling just before Murthy on that, where they did find coercion by a government actor, but it was very blatant. I think it was in writing, as I mentioned. And so clearly, if we find good facts, it's easier to make a good case and start to, take a bite at the apple here and there. The other thing, I think everyone needs to be just to be aware, and I think it becomes trite when we say that, let's all be aware. But the First Amendment is a lot more fragile than I would have expected. When I was growing up, the First Amendment was was in the purview of the left. You had groups like the ACLU, and they were always talking about the First Amendment, and oftentimes kind of stretching what liberties they felt that the people were entitled to. And an interesting thing happened over the last few years. It seems like those groups, like the ACLU or others that have traditionally supposedly been champions of the First Amendment, have become very silent. They're nowhere to be found when it comes to censorship these days.
Why is that?
I wish I knew. If I had to guess, I think it's because philosophically, the benefits of censorship are in their favor. The people being censored are typically on one side of the political spectrum, and it's not theirs. And so it's easy to turn a blind eye when that happens.
It's interesting. Yeah, I like that. How do you see, kind of talking about like things like ACLU, or just really in general, just the legal landscape evolving around algorithmic moderation. When you talk about things like AI, things kind of get crazy going forward. How do you see legal landscape evolving, making these platform design decisions?
Yeah, I think it's an all hands on deck kind of effort. I don't have an easy answer or a silver bullet other than to say, I think it's the work of a lot of groups, mountain states included, states attorneys general that are willing to engage in this fight to constantly keep that pressure on. We've seen recently in the national news, Mark Zuckerberg, for example, he's now kind of singing a free speech kind of tune. And, we can debate whether we think that's sincere or it's just political pragmatism because the administration has changed and now it's to his advantage to be that way. But the point is that legal pressure and that sunlight and exposing what's going on, litigation in many cases, these can be valuable in helping to stave off censorship, or to, in the case of AI, as AI is being, coming into its own and it's developing, let's have a seat at the table. Let's constantly push back when we think that AI is being tailored in such a way that's going to potentially inhibit some of our constitutional rights. Eternal vigilance, they say, is the price of liberty.
Because now you're also getting the cases of like attorney-client privileges where people are using AI to be their lawyers and attorneys, and that gets crazy in itself. We were having a whole 20-minute debate in the legal meeting the other day about like what's work privilege and what's. I was just like, oh my gosh, it's my third month out here. I don't know what's going on. Or work product doctrine. That's what I meant, not work privilege. But
you've learned a lot in 3 months. You speak fluent legalese already, so you're.
Thank you. Well, it's sitting down with cool people like you and just trying to break it down into kindergarten terms, but that's what we're doing for everybody else, because I don't understand a lot, so I'm assuming that people there also have these kind of questions. But if you could leave the audience with one question to think about regarding free speech and or social media regulation, what would you have them ask themselves?
I think it's something we alluded to earlier. The most dangerous thing for the First Amendment and a lot of these other constitutional guarantees is when people start to self-censor through fear or some other kind of threat of coercion. If we become a society that is unwilling to say hard things, is unwilling to speak truth, is unwilling in some cases to litigate for our rights, those rights fade, and then pretty soon there's just not enough people that are there to really protect them and live them out to keep them vibrant. And so don't self-censor, even if the pressure is on. I think we've all learned something from the COVID era, for example, when there was this just overt pressure and censorship in all kinds of ways. Let's not give into it. It's very difficult if a nation, if a large group of people is committed to protecting their rights and exercising their rights. It's really difficult for the government to overcome that. So, don't self-censor. If you have kids or if you have grandkids, let's talk about these things. Let's talk about the First Amendment. I mean, their eyes might glaze over a bit, but let's teach the next generation why these things are important, and just be ever vigilant, and don't be afraid to step into that gap and to be the person that maybe takes a controversial stand to ultimately defend those rights and preserve them for the next generation.
Yeah, that spiral of silence could be crucial, especially when it's biological that we want to fit in. It could be dangerous when you're unconsciously fitting in and not putting a conscious effort towards it.
Absolutely.
I agree. Is there anything that you think we overlooked or that needs to be touched on more before we wrap up here?
Wow. I mean, you put a mic in front of a guy, and obviously I could talk all day about this, but I would just say at a high level, there's so many things I wish we could talk, for hours about. The findings in the Murthy case, getting away from some of the standing and some of those more arcane legal arguments. When we got into this case, we were shocked at what we found. And so take examples like the Hunter Biden laptop, which the FBI had in their possession for something like a year. And then they knew that there was this, the New York Post story ultimately broke this news of this laptop, right? Well, what we found through some of our discovery, that for months and months leading up to the 2020 election, the FBI and others had been constantly meeting with the social media companies in San Francisco. In fact, I went to San Francisco where we deposed a key FBI agent who we believe was responsible for some directly responsible in many cases for the Hunter Biden laptop cover-up. And so what would happen, they would meet with these social media companies, the FBI, and they would constantly warn them that there was a Russian hack and leak that was coming. And so they groomed them for weeks and for months to be on the lookout for a hack and leak operation.
Quote, unquote.
Quote, unquote. And so they really indoctrinated these companies that this was coming. Now, interestingly enough, we're here in Colorado, and just up the road in Aspen, just due west of here a few miles, in June, I believe, of 2020, a summit was convened, the Aspen Institute. And so they have this whole media mock-up where they run through this tabletop exercise, and you can go out and Google it and find the documents online. But they actually did a tabletop exercise. What would happen if this mysterious laptop hits the public airwaves right before a presidential election? And they all but said the names of Hunter
on this
and
day
Joe Biden.
at this time.
Yeah, I mean, nobody was fooled as to what they were talking about. So that plan was in place. The FBI was grooming these companies to be ready for it. And so when the New York Times or the New York Post story drops, I think in late October, right before the election, the signal was apparently given, is my belief, that the FBI gave the signal. The social media companies had been told something big was coming, and they thought, this is it. This is what the FBI has told us about. And they moved forward and they censored that story, right? I remember trying to forward it from my own Twitter account and was physically unable to share the story. So we were all censored. And they did that. I think there was some polling that was done later that showed that had the American people been privy to all the details of that on the eve of the election, it could have well flipped the outcome of the 2020
It was a very short margin.
Yeah.
It was about 30,000 people in that vote in that window between when it leaked and when the election day was coming. So, yeah, it's huge.
Very small, and that was such an amazing story. I never would have thought that was truth. But we found so many facts supported that narrative. A similar narrative was with Dr. Anthony Fauci. We went to Washington, to the National Institutes of Health, and we deposed Dr. Fauci. And in 7 hours of deposition, he claimed something like 212 times to not remember particular facts. Well, it was also clear from the record that when the virus escaped in Wuhan, that the NIH had been a very important part of funding this research going on there. Well, when it blew up, in the sense that the virus got out and now it was spreading all over the world, there was a high-level meeting convened late January 2020 to try to cover their tracks. And so just to watch them scurry around and try to cover their tracks to actually invent scientific literature, and I think it was in the journal Nature called The Proximal Origins of the COVID Virus. Dr. Fauci pretended this was just some independent work of science that debunked the theory, when in fact he had probably reviewed 5 or 6 different drafts of that very paper. And so under the nose of then President Trump at the Oval Office, he's telling reporters, oh, you should go look at this great paper that's out there, as if he didn't help concoct it. And so just the level of deception, the level of government involvement in twisting and shaping the narrative was something I wouldn't have believed before our team really jumped in knee deep into this story. And sometimes truth is stranger than fiction.
Yeah, it's historical too. This isn't even just in these instances of recent history. This is going back hundreds of years, even with these kind of governmental interactions and covering the fingerprints, as you said earlier. So I appreciate you bringing that up, because that was a huge thing that I found, especially leading up to the Murthy versus Missouri case. But I genuinely, I think this was one of the coolest episodes, and I think I had a really great time talking with you, Todd, and I appreciate you taking the time to come out here all the way from Missouri as well. So thank you.
It's my pleasure. Noah, thanks for taking the time to ask me these questions. Love talking about it. Love the work you all are doing. In the fight for liberty and the constitutional rights, it takes so many, and so we're glad that Mountain States Legal Foundation is out here doing your great work out here in the Mountain West.
Awesome. And we always encourage our audience to go out and read this for themselves. You know, none of this is just happening on a podcast. It's none of it's theory. It's all written down somewhere, whether it's in an investigation or a paper or somewhere. You can definitely find everything and fact check us. But again, we appreciate your time, Todd. And that is episode 3 of Beyond the Bench. We will see you all next time.